So I think it's recording. Hi, everyone. First of all, I apologize not to being there with you in person. Unfortunately, didn't really work out with my schedule, and I live currently in Switzerland. Um, I'm a good old friend of Kevin. We studied together in California, Berkeley, and I'm very happy to be here and present to you uh, one of my one project that is part of my PhD dissertation here at ETH Zurich. I'm currently conducting, trying to finish up actually, a PhD in law and economics, and I will tell you more about it in a second, what that entails. But first, Kevin asked me to talk a little bit about myself. I wouldn't say that's a stronghold of mine, but I'll share my CV with you for that to explain a little bit what I did so far in my career and how I started. Um, you should see that now. And as you can see, I'm actually originally from Zurich. I did my bachelor's and master's here at University of Zurich. And then I didn't have enough of studying at university after my master's in Swiss law, and I decided to pursue a second master's degree in US law, um, to know a little bit about the laws from a different jurisdiction, especially a common law jurisdiction that was important for me at that time. And that's also where I met Kevin. Life-changing experience. We had a wonderful time in California, and I hope to go back soon. And after I finished my studies, I actually was trying to do the bar exam, or I did the bar exam here in Zurich to become a qualified lawyer. And in order to do that, I had to um, do a mandatory internship. I did this as a prominent at a prominent law firm here, corporate law firm, a big one here in Zurich in Switzerland. I did like some M&A and IP IT stuff and litigation and some white collar crime cases that was very interesting for nearly 2 years. And then afterwards, I was sitting the bar exam that is here in Zurich that takes nearly a year to sit the bar exam. It has half a year studying for the written part and then half a year for studying for the oral part. And after that, I decided actually to go back to university again and pursue a PhD. As part of my PhD, I had to take some courses and finally also got a degree in applied statistics from ETH Zurich. Um, the reason for that was that I do in my research here, I do empirical work. What does that mean? That means that we try to take empirical facts or measure empirical facts and embed them in legal debates. We try to make empirical arguments or use empirical facts, empirical findings to answer legal questions. Okay. And on the side, I'm a little bit practicing as an attorney here in Zurich. I do a lot of criminal law, try to do a lot of pro bono work since I more or less fully employed here at ETH, as you can see here. Here, that's already said that I'm a self-employed attorney. I wanted, after all the studying I did for the bar admission, I really wanted to use it. Um, yeah, and I had some extracurricular activities, such as spent quite a while in the military. I did a mandatory training for nearly a year, and then I did repetition courses every year. I went back to the military for a month in the special Swiss Special Forces that entails a lot of mountain training and so on. And yeah, I've worked for the Swiss Embassy in Cairo a little bit, and I also rode across the Atlantic Ocean with three friends as part of a race. But about that, maybe I can tell you another time. That takes a little bit while to explain that further. Okay, but now enough of me. Let me start with the interesting stuff and my research on the digital debt. My research on the regulation of digital markets, at least one project. So I will stop sharing and now start sharing again my slides. Perfect. I hope that works. Cool. And as I said, I'm presenting today a project about consent and how to measure voluntariness empirically. This is joint work with my PhD supervisor, Stefan Bechtold, here from professor at ETH Zurich. So in this paper, we argue that whether an individual provides voluntary consent is often not only a normative, but also an empirical question. Consent is central to many areas of law. Consent is, for example, a prominent issue in the digital markets regulation, privacy, but also for the EU Digital Markets Act. But consent is also a central legal concept to contract law, criminal law, or medical law. And in this project, we use Meta's reaction to a European Court of Justice decision to illustrate how to measure consent voluntariness empirically. Now, I really wish I would be here with you because normally here I ask a question that is, not yet, sorry. Who in here has a Facebook or Instagram account of you guys? I guess most of you. And the second question I want to ask you is, who of you pays to use Facebook or Instagram? This question actually only goes to the European. Kevin told me there is also some European audience. If you don't have ever heard of it, no problem. And if European have never heard of it and not paying, no worries, because neither do I. But actually, in fall 2023, Meta introduced the option to pay €12.99 a month to use Facebook and Instagram without advertisement. Later, Meta then reduced the price to €7.99 a month. So users in the EU, in Switzerland and other European countries have the option to pay for Facebook and Instagram and use these services without ads. Now, this sudden policy change by Meta did not come from some sincere concern about our privacy, as you can imagine, but was arguably driven by a decision of the European Court of Justice. As most of you know, under Article 4, Paragraph 11 of the GDPR, consent is only a valid legal basis for data processing under the GDPR and under the DMA if it is given voluntarily. Freely given is the wording of that is used in the GDPR. You can find similar wording in the California Consumer Privacy Act. Now, in July 2023, Europe's highest court, in said judgment, specified the requirements for voluntary consent in the context of large online platforms and stated that users must have the ability to refuse consent without losing access to the service. The court then went on and held that this actually means that those users are to be offered, if necessary, for an appropriate fee, an equivalent alternative not accompanied by such data processing operations. However, it turns out the European Commission disagrees with the court's legal interpretation of voluntary consent, and just 2 months ago fined Meta 200 million because they consider user consent involuntary, and the current regime implemented in response to this court's decision as invalid, not allowing for voluntary consent, and then voluntary consent using, so because there is no voluntary consent is not valid, and consent cannot be used as legal basis for data processing under the GDPR and under the DMA. And it is before this background, this legal debate between the European Court of Justice on the one hand and the European Commission on the other hand, that we posed the question whether Meta's consent or pay model that was implemented in response to this judgment of Europe's highest court allows for voluntary consent to targeted advertisements. So, but now before we move on to the cool stuff, the empirical design and the empirical results, let's quickly recap the court's reasoning. Before the policy change, users had two options: consent and use Meta products for free, do not consent and lose access to Meta products. This is what we call in our framework the consent or lose access choice. Court and regulators agree that consent under this choice architecture is involuntary in the EU. And after the policy change, users have now three options, the same two options as before: use the services for free or stop using Facebook and Instagram. But now users have a third option, the option to pay and use services without ads. And now the most important point, this additional outside option should render consent of those users that continue using the services for free with advertisements voluntary, at least as far as the theory of the court goes, because this is exactly the point where the court and regulators disagree on. The court assumes that users see the option to pay as a viable alternative to consenting. The pay option provides more freedom in this decision and makes this decision more voluntary, therefore. The regulators, on the other hand, believe users perceive the option to pay more as a financial threat in case they refuse consent. Therefore, the option to pay does not make the decision more voluntary. And this illustrates nicely how court and regulators start from different empirical assumptions and consequently answer the initially posed legal question differently: whether Meta's consent or pay model allows for voluntary consent or not. Court said yes, commission said no. And how do we find out who is right in answering this legal question? And now we come to the main argument of this paper. We argue that we find out who is right by testing the empirical assumptions made by the court and regulators and asking the following empirical question. Do individuals perceive the consent, pay, or lose access choice, the one with three options, as more voluntary than the consent or lose access choice, the old one with only two options, the one that is still implemented in the US? This is also our research question. So what we do is we test the court's assumption that the consent or pay model makes the decision to consent or not more voluntary. One thing I want to highlight here is that court and regulators actually agree on that consent here on the left-hand side. If I look at the screen, probably for you on the right-hand side, court and regulators agree that this consent or lose access choice is involuntary, because they argue that these services has become such an important part of the social life of users that you cannot give them such a all or nothing choice. Like, you basically force them to consent because otherwise they can't use the services. That's the argument of court and regulators, and they agree on that under this old system, consent is not voluntary. Now, the method we use to answer our research question is a vignette study. In June 2024, we conducted an online study on Prolific. That's like a platform where you can recruit participants for experiments. And we recruited about 880 participants from the two largest countries of the European Union, Germany and France. This was pre-registered, of course. And we manipulated a single factor on 6 levels, resulting in 6 treatments. Treatment 1 corresponds to the choice situation before fall 2023, the consent or lose access model. Remember, that was considered involuntary by court and regulators. Treatment 2 to 6 offer now the option to pay at different prices. And you can see here on the screen that participants can indicate the option they would choose. However, we are not interested or not primarily interested in their behavior, because behavior is not what matters to the law. Court and regulators, they did not make empirical assumptions about which option users would choose, but about how they perceive the decision. Therefore, we measure participants' feelings. Do they perceive these different choice architectures as more or less voluntary? And to measure this, we adopted 2 measurements from studies to established measurements from studies in psychology. We measured a thing called perceived autonomy, suggested by Sheldon and others. And we measure perceived coercion used by Gardner and by a study of Gardner et al., where they were actually measuring patients' perception of coercion during mental hospital admissions. Now, these statements, they correspond to this different aspects of autonomy and coercion. For example, the freedom statement, is supposed to correspond to the restriction of freedom as an aspect of coercion. And participants indicated their agreement to these statements on a 5-level Likert scale. This is like, Likert scales are these scales where it's got, I fully agree, I partly agree, I'm neutral, I partly disagree, I fully disagree, something like this. So what we did is we analyzed the difference between the treatments for every single statement, plus we created indices where we took the mean of the answer to the 3, respectively 4 statements to answer our research question. Okay, so now let's move on to the most exciting part of this research, our results. And to mirror this excitement a little bit, you see here a cool climbing picture to get everyone's attention. Kevin told me it's afternoon now here, so you all should be tired. And this is unfortunately not me. I wish. So first, let's have a look at the perceived autonomy index, the mean of the answers to the 3 autonomy statements. And you see here the box plots of the 6 treatments, and below you see adjusted p-values of the Mann-Whitney-U tests. And what is important, we compared treatment 1, the no option to pay, with treatment 2, $12.99 a month, treatment 1 with treatment 3, and so on. Because what we're interested in is whether the option to pay at different prices changes the voluntariness, the perceived voluntariness, compared to the consent or lose access choice, where consent is considered involuntary. And I want you to focus on 2 main results here on the bottom. One, the options to pay $12.99, $6.99, and $1.99 are statistically indistinguishable from the consent or lose access choice. And 2, we see a strong statistically significant effect of the option to pay 10 cents a month. And these are our main result. You can see here on the slide the option of the 10 cents a month. When there is an option to pay 10 cents a month, people felt that the decision allowed them to have more autonomy. And this, you see this by the difference that it is higher, the average number, they're closer to 4. And you see this by the highly significant p-value. These are 2 main results. I want you to keep them in mind. Now, I also want to show you the autonomy results per statement. The 3 perceived autonomy statements, they support the previous results from the index. The options to pay at prices above €1 do not really make a difference, but the 10-cent option does. Now, let's also have a look at the perceived coercion index that shows similar results. No difference of the $12.99, $6.99, $1.99 options, and a significant difference of the 10-cent option. And finally, the results for the 4 perceived coercion statements, where we see the same strong results for the first 2 statements and some similar trends, but no clear results for the 3rd and 4th statement. Now, so to answer our research question, whether individuals in fact perceive the consent or pay or lose access choice as more voluntary, the answer is yes. We found that the option to pay, but only the option to pay 10 cents a month, increased participants' perceived coercion. We saw that throughout all the measurements. Perceived autonomy, perceived coercion, index, statements. It was a pretty consistent result that people feel the decision to be more voluntary when they have an option to pay 10 cents a month, compared to the old consent or lose access choice. Now, the question is, does this answer the initially posed legal question? I want you here to highlight again, there is a difference between the legal question and the empirical question. Sorry for getting an email and not having muted this. Now, again, the question is whether this answers the initially posed legal question. That is, does this imply that users' consent is legally involuntary in Meta's consent pay or lose access model at prices, let's say, above €1, to be a bit conservative? We argue yes, it does, for 3 main reasons. And thereby we want to outline a roadmap for such a normative conclusion based on empirical findings. First, a normative legal question must involve empirical assumptions. In this case, I showed you how court and regulators, they made different empirical assumptions about how users perceive the option to pay. That speaks for the relevance of empirical facts for this legal debate. Second, we need a benchmark for the empirical test. In this case, the consent rules access model, the pre-2023 model that was repeatedly declared involuntary by court and regulators, is the perfect benchmark to which we can compare the empirical level of voluntariness to. That's the model with only two options, that is involuntary. And third, of course, the study must be externally valid. External validity, that means that we can take the results from the study and that they are applicable in the real world. They're never fully applicable in the real world. There's no such thing as completely external validity, but we try to get closer. And what I mean by saying a study must be externally valid is that there are arguments that speak in favor of applying these results also to the real world. And such as that our study scenarios are very close to reality. Every participant in our study either has Facebook or Instagram in real life, or is aware of the possibility to sign up to these services. Therefore, every participant in our study faced our vignette scenarios before in real life, which is very good for the external validity of our study. And for these three reasons, mainly, we argue that in our study, we actually measured the legal voluntariness of consent. And we can conclude that the options above €2 a month do not allow for voluntary consent. So, to conclude and sum up again a little bit, in this paper, we propose this novel framework to empirically measure voluntariness in different choice architectures. We use for the first time such a thing called perceived voluntariness compared to a previous study that used to focus on behavior click rates. As I said, our approach is based on observing emotions and not mere behavior. And when we apply our framework to the present legal question, we find that Meta's consent or pay model does allow for voluntary consent, but only if the price is €1 or less per month, which is completely unfeasible for Meta. So what does this mean for privacy law, data protection law in Europe? We interpret our results as just once more demonstrating the limits of consent-based privacy and data protection laws, because users have inconsistent preferences and are pretty unwilling to pay for such services. And with that, I want to thank you very much for your attention and welcome. Here in my notes, it says, welcome your questions. I wish I could answer your question in real time, but I told Kevin and we agreed on that if you have questions, I'm more than happy, please tell them to Kevin. He will forward them to me. First thing tomorrow morning when I wake up, I will get on the computer and answer your questions. But thank you very much for listening. And also, anytime, if you have questions or feedback, please do not hesitate to contact me directly. Cool. Okay. I hope that was interesting. It was not too empirical. This is what we do here at ETH Zurich. We use empirical, we do studies, we run experiments, we analyze observational data and try to embed these empirical findings in a legal debate and hopefully answer interesting legal questions. Thank you very much.